and thank you for joining us today. My name is Michaela Romesser, and I'm a senior associate at Scott Legal PC. Today, we are going to spend some time and talk about the E-1 non-immigrant visa. Just a few things before we get started. So Scott Legal is a full-service immigration law firm, and we assist individuals pursuing various types of visas and green cards. And we regularly process a high number of E-1 visa cases. We will continue to have this webinar series, and we will do at least 2 webinars a month on different visa and green card topics. At the end of this webinar, we'll send you out a few things. So we'll send you a PowerPoint that will be used during this webinar. We will send you a comprehensive E-1 visa guide, and we will also send you a link where you can sign up for additional webinars we will have in the future, and also a link where this webinar will be recorded. This webinar will also be available on our YouTube channel, and we encourage you to subscribe and hit the notification button on our YouTube channel, as we often upload new immigration videos. And finally, we will also send you a link where you can set up a consultation with one of our attorneys if you would like to discuss your E-1 visa case in more detail. Finally, if you have any questions as I talk, please feel free to put them in the chat box or in the Q&A box, and I will get to all questions at the end of the presentation. So why don't we get started? So E-1 visa is a non-immigrant visa for a person or a company who is a trader and who engaged in substantial international trade between the US and their home country. So let's go over the E-1 visa requirements. So the first requirement is that, the E-1 visa is not unfortunately available to nationals of all countries. So you have to be a national of E-1 visa treaty country to be able to apply for an E-1 visa. Many countries all over the world are E-1 visa treaty countries. So for example, many countries in Europe, like Germany, Italy, the UK, Latin America, Africa, Asia are E-1 visa treaty countries. So you would just need to double check whether, your country is on this list. What is important here is that you only have to have a passport of E-1 visa treaty country. You do not have to be, born there. So what matters is the country of nationality and not the country you were born in. So for example, let's say that you were born in India, which is unfortunately not an E-1 visa treaty country, but then later in your life, you got a nationality of let's say UK or Canada. You would be able to apply for an E-1 visa with that UK or Canadian, or any other passport, as long as the country is E-1 visa treaty country. So the next requirement is that because it's an E-1 visa treaty trader visa, is that there must be an ongoing trade between your country, the E-1 visa treaty country, and the US. So what does this mean? So, there must be an actual exchange of qualifying commodities that is traceable and identifiable between your country and the US, and the trade must be already in existence at the time you apply for an E-1 visa. And we'll kind of go over all these requirements in more detail on the next slide. Then the trade must be, the trade between your country and the US must be substantial. So, unfortunately, not all trade will qualify. So you will have to show that, the trade you or your company is kind of like engaging in is substantial. And again, we'll go over, what does substantial mean in more detail on one of the next slides. The trade must be international. So this requirement basically means that, let's say that you have a company in your home country, and this company is trading with, different countries all over the world. you will have to show that at least 50% of all the international trade is between your country and the US. So this means that the trade must be principally between the US and your home country. The next requirement is that you must be coming to the US to engage in substantial trade. So this requirement basically means that you are coming to the US to kind of like manage, direct, and develop the company. Like you'll be kind of like actively like working for that company. And then the next requirement, the last requirement, is that you must have intent to return to your home country when the E-1 visa expires. This requirement for an E-1 visa is can be kind of like easily met. Generally all the government kind of like needs is a signed declaration from you that says that basically once your E-1 visa expires, you will return to your home country. So it's not you don't have to submit kind of like extensive evidence of your ties to your home country or anything like that, like you would normally have to do, for example, for a B visa. So as I said, like usually this requirement can be met by submitting a signed declaration from you, declaring that you will return to your home country when your visa expires. Okay, so now let's go over, so what is trade? What can qualify as trade for E-1 visa? So item of trade can be basically any item that is commonly traded in international commerce. So, of course, any goods will qualify as items of trade. So, for example, if you are like trading, selling, like fabrics, like any materials, like furniture, clothes, like anything tangible, like that would of course qualify as item of trade. And for an E-1 visa, also services can qualify as items of trade. So, for example, let's say that you have a company in your home country, let's say, for example, Italy, which is an E-1 visa treaty country. And, this company is providing consulting services to US clients. Then these services could qualify as item of trade, and you could potentially as long as you meet all the other requirements, you could qualify for an E-1 visa. So how, let's say that you, like you are trading and you are thinking, like what documents will I need to submit to kind of show that there is an ongoing trade between your home country and the US. So, one good thing to do always is to, if you are applying at a consulate, is to kind of check, the consulate's website, because different consulates, have like different preferences of like what documents they want to see. But generally, they want to see kind of like a trade spreadsheet for the last couple of years that kind of show, like what was the amount of trade in the last couple of years, like how many clients did you have in the last couple of years, how many, like transactions or invoices you issued to each client in the last couple of years, and then kind of like the monetary value of each of those transactions. Then we usually also submit kind of like a sample of invoices you issue to your clients. If you are importing goods to the US, we could also submit bills of lading, that show that the goods entered the US. Sometimes, like some consulates want to see the company's bank statements, that would show that you were kind of like receiving the payments from clients. Again, if you were importing like goods to the US, we could submit DHS customs documents, again showing that the goods entered the US. And it's always good to submit your company's tax returns, that show that you were taking revenue from client, and there is this ongoing trade already happening. Perfect. So, as I mentioned in the beginning, one of the requirements for an E-1 visa is that the trade must be substantial. And so what does substantial mean? So unfortunately, there is no kind of like exact definition in the regulation that would say, like if the trade is $100,000 per year, that means substantial. So unfortunately, nothing like that is in the regulation. And instead, the government wants to see that there is a continuous flow, of the trade between the treaty country and the U.S. So what does the continuous flow, mean, or how does the government kind of like make a decision whether the trade is substantial? So, they usually want to see that, there are kind of like, the trade has been ongoing, and there are, like numerous trade exchanges between the U.S. and your treaty country over kind of like like longer period of time. So our kind of general recommendation is that the trade is in existence for at least 6 months before you apply for the E-1 visa. And then we generally recommend that the trade is at least $250,000 per year. This is general recommendation, like, of course, like each case is individual, and we would kind of like look at all the, like all the different factors. We would look at how many clients you have had, how many transactions there were, and things like that. But this would be kind of like the general recommendation. So, like when consulates kind of like make a decision whether trade is substantial, they will look at, the monetary value of the transaction. So they will look at how much trade, how high was the trade in the last couple, like this year, last year, in the last couple of years. Then they will look at how many clients did you have, like do you have now, and you have had in the last couple of years. They will look at, like how many invoices did you issue to each client in this year and in the last couple of years. And then they will kind of like look at all these things and then make the decision, like, is this trade substantial? One thing I wanted to mention is that, like a single transaction, even, like let's say that your company sold something to a US client for like $3 million, but you only had that one US client, and there was only this one transaction between you and the US client. Like, even though the transaction was like, like really, like really high in value, $3 million, this would never be enough, for you to qualify for an E-1 visa, just because, like you wouldn't meet that continuous flow requirement. So again, like the government wants to see that there are multiple different clients, there were like multiple, like transactions with each client. And then, then they will also look at the monetary value of, of all of those transactions. So now, can a small business qualify for an E-1 visa? The answer is yes. It's kind of like explicitly said in the regulations that, smaller businesses can qualify for an E-1 visa. So, in this case, the focus would be, like even if you don't meet the kind of like the general recommendation, as I said, the $250,000, but like let's say the trade is like $150,000, but you have, for example, like 30, 40 different clients, and with each client, like you have in the last 2 years, like you have done like 20, 30 transactions with, like with each of those clients. You could potentially, like still qualify for the E-1 visa, even if the kind of like the monetary value of the transactions per year would be kind of like on the lower side. So, in this case, if your business is kind of, like the monetary value, the trade per year is kind of like on the lower side, but you have a lot of clients, it may be good to kind of like submit a business plan with your application, and just to kind of explain, like the plan, like how you plan to get additional clients, in the, in the future to kind of show that, the trade will increase over time. So another thing to keep in mind here is that, you do have to show that the trade is substantial at the time you apply for the E-1 visa, but the trade must also stay substantial, after your E2 visa is granted. Because, like, let's say that it kind of like substantially drops, then you may have a, like very difficult time like renewing the visa. Okay, so let's go over some other trade considerations. One question we often get from potential clients is, like, must the trade already exist at the time I'm applying for an E-1 visa, or can I just kind of like come to the US and start a company and start kind of like trading with clients after I get the E-1 visa? So the general rule is that yes, the trade does already have to exist at the time you apply for the E-1 visa, just because like you have to meet the requirements of substantiality, the requirement that the trade must be international. So I would say that the general recommendation is yes, the trade must already exist. There is one exception, and that is that like let's say that the trade is very low, but you have signed kind of like binding agreements with clients for kind of like immediate performance of work. You could still potentially qualify for an E-1 visa. So like let's say that like you have a company in your home country, and like you just like the company just started it, let's say 3 months ago. The trade is like has been $30,000, but like you signed binding agreements with 5 US clients, and each of that agreement basically says that the company has to start performing work in the next like month or so, and the monetary value under those agreements is like hundreds of thousands of dollars, or like even like 50 or $100,000. In that case, I would still say that the case may be on the riskier side, and it may be better to kind of like wait a little bit. But there is one exception in the regulation that says that, like basically when the E-1 trader signed binding agreements, the trade may be like maybe on the kind of like on the lower side. It may be possible that the E-1 would be approved in this case. So now, how much of the trade must be between the US and the treaty country? So as I said, at least 50% of the international trade must be between the US and the treaty country. And one important thing here is that, we only look at the international trade. So like, let's look at this example here. A company in Spain manufactures glass and exports it to other countries, and also just trades within Spain. So, sales within Spain is $100,000. Sales to the US is $500,000, and sales to China, are $500,000 as well. So in this case, we would basically, because as I said, we only kind of like look at the international trade. We would disregard the sales within Spain because that's domestic trade. And you would, in this case, the company or the individual could still qualify, because at least 50% of the trade of the international trade is with the US. Perfect. So let's move on and let's talk a little bit about E-1 kind of application process. Like, is it better to apply at a consulate versus USCIS? So I would say that our general recommendation is that people apply for an E-1 visa at a consulate. The reason is that so let's say that you do a change of status with USCIS. So this is only possible if you are in the US on some other visa status. ESTA wouldn't qualify. You have to enter on certain visa, and then you would have the option to change status with USCIS. The change of status, the advantage of it is that you can stay in the US, while the application is pending, but you do need to wait for the USCIS approval to be able to actually start working for the company. If the change of status is approved, one kind of disadvantage is that it's only going to be approved for 2 years. That's kind of like the maximum period of time USCIS will give you. And if you want to travel internationally during the 2-year period, you will need to apply for an E-1 visa at a consulate to be able to come back. So, the change of status, I would say it's usually, people apply for it like if they know that they do plan to only stay in the US, for the 2 years, and they don't plan to travel. Because let's say that you apply for the change of status, it's approved, but then you already know that you are going to travel in like the next 2, 3, 4 months. You will need to apply for the visa at a consulate anyway. And one advantage of applying at a consulate is that many countries, the kind of like the reciprocity period or like the period of time the E-1 visa can be issued for is 5 years. So, let's say that you are, for example, a national of, Canada or the UK, both of those countries, nationals of those countries can get the E-1 visa for a period of 5 years. So if the E-1 visa is approved, it's going to be approved for 5 years, and you can travel in and out the US for a period of 5 years. So that's, again, like each case is different. Like some people may have preference to just kind of stay in the US, but the general advice, or generally people apply for the E-1 visa at a consulate just because the ability to travel internationally. So let's talk a little bit about some E-1 visa developments and adjudication trends. So one question we often get is that do you have to live in the US once the E-1 visa is issued? Or let's say that someone got an E-1 visa in like 2019 and wants to renew it now. And, because of COVID or because of some other reasons, this person was not living in the US for majority of time, and many people are concerned, is that required? Like, did I violate some requirement, or kind of like, what's the rule on that? So the rule basically is that, if you get the E-1 visa, there is no requirement that you kind of like move to the US, immediately, or you move to the US and live here kind of like permanently. So, and some people actually do prefer, because they have like other businesses in like other countries, they just kind of like want the E-1 visa. So they have ability, if they want, for some period of year to come to the US to kind of like manage the US business, but then, they just kind of like want to stay a couple of weeks or a couple of months and then kind of leave. And that's completely fine. So there is no requirement that once you get the E-1 visa, you move here and you just kind of like live here for the period the visa is valid. So it's completely fine if you, kind of like split time between the US, your home country, or some other country. Like, there's no minimum amount of like days you would need to spend in the US on the E-1 visa. The other thing we kind of see now when doing, renewals for, or even like initial visa, E-1 visas for people, is that, people are concerned, they say like, oh, the trade now is, pretty high. The company is doing pretty well, but like during 2020, 21, 22, because of COVID, the trade kind of decreased, is this going to be a problem? What should we do? So I would say that, like the consulates are usually pretty understanding. They understand, like what happened, like most of the companies in the world, most of businesses were affected by COVID. So like if we are doing renewals, we would kind of, explain in the application, the reason, like why the trade decreased for certain period of time. But, the important thing is to kind of show that at some point, the trade kind of increased again, the trade picked up and, so we would kind of explain the, kind of like the decrease in trade and then kind of focus on the fact that at some point, it increased again and kind of focus on that in the application. One thing I wanted to mention quickly is, so it's kind of like the possibility of other employees to get E-1 visas once, like you get your E-1 3D trader visa. So like, let's say that, like you have a company in the US that is trading with your home country. The company in the US is, like let's say exporting something to your home country and you get E-1 3D trader visa for that company. And, like in a couple of years, the trade kind of like really picks up and you kind of have some employees in the US, but like you find some employee in your home country and you want to bring that employee to the US to work for the E-1 company. So this is possible. There are basically 3 categories of employees you can bring from your home country. I will just go over them really quickly. So like one is like if you want to bring like a manager to the US, so like for example, operations manager, general manager. The other is executive. So like let's say that, like you want to bring like a CEO, CFO, or, some other executive who will kind of like run the company. And the third category is specialized skills employee. So this would generally be some sort of employee that has some skill set that is essential to the operations of the US company. And just one thing to keep in mind is that the employee, like let's say that, for example, you are an Italian national, that employee, and the trade is happening between the US and Italy, that employee would also have to be a national of Italy to to qualify for the E-1 employee visa. And another thing I just kind of quickly wanted to mention is that, your family members, certain family members can also get E-1 visa. So if you are applying for an E-1 3D trader or even the E-1 employee visa, your spouse can get E-1 spousal visa, and then your children who are unmarried and under the age of 21 can get also E-1 visas. Your spouse can work in the US. They get kind of like automatic work authorization to work in the US. So, that is great. And then your children can study in the US. So that is, a great, especially for the spouses, because not all spouses of non-immigrant visa holders can work in the US, but the E-1 spouses can. So that's a great advantage. Okay. So let's go over some other things, business plan, employees, business entity. So, one question we often get is, do I have to submit a business plan with my E-1 visa application? So the general requirement is that business plan is not required for an E-1 visa. I will say, so like, let's say that your company has been, the trade has been ongoing for, for example, last 5 years, the trade in each year was around like, I don't know, $500,000. You have multiple clients, multiple employees. In this case, I don't think a business plan would, you would need to submit a business plan just because the application would be pretty strong without it. But like, let's say that, you just kind of like started trading, like a year ago, the trade is around like, I don't know, 250,000 a year. And, you have like 5 or 6 clients. You know, in this case, it may be good to submit the business plan just to kind of show and describe in the business plan, you know, like how you plan to get additional clients in the future, how, you know, like what do you expect the revenue to be in like the next 5 years, just to kind of, you know, like, do you plan to hire employees in the US, just to kind of show the government that, you know, like, yes, you just kind of started, you only have 6 clients, but like in the next 5 years, you know, the company will kind of grow significantly. So I will say, like, in some cases it may be beneficial to submit a business plan with the application. So there is you know, other thing is, you know, some people ask, like, do I have to hire in, you know, like once I come to the US, like, do I have to hire employees in the US? You know, the answer is no. So there is another type of visa, E-2 investor visa. For that kind of visa, you know, you absolutely have to hire employees in the US. For the E-1, you don't have to. You know, there is no requirement. I will say that, you know, like if you are kind of like, if you have a company in the US or you are setting up a company in the US, and you do think that you will hire employees like in the next 5 years, it may be kind of, you know, like helpful for the case to kind of like mention it in the application, just kind of briefly, you know, like what types of employees do you plan to hire, when, because you know, like the government, I mean, it's always, you know, like good to see in the application if the business will hire US workers. So it's not a requirement, but if you do plan to do that, you know, it may be helpful to kind of mention it in the application. And then, you know, do you need a business entity when, you know, if you want to apply for an E-1 visa? So there's no requirement to have an entity. You know, the treaty trader, the definition is that it can be individual, partnership, joint venture, or a corporation. So there is no requirement to have a company, but many people, you know, like prefer to have kind of set up a company just for, you know, like tax liability purposes, stuff like that. So I will say that, you know, in most cases there will be an entity, but it's not required. Okay, so what are some common reasons for an E-1 visa denial? So I will say, you know, like the one common reason is that the trade amount is just too low. So, you know, like let's say that you apply for an E-1 visa and the trade, you know, like let's say like in 2023, 2022 was only, you know, like $60,000, $70,000, you know, that is just too low for an E-1 visa. So the officer, you know, may have denied because of that. You know, the other reason is, you know, like let's say that the trade amount is a little bit higher, but you only have like 3 or 4 clients you are trading with. You know, again, you know, as I said, like one of the requirements is that there must be that continuous flow, you know, of transaction and like continuous flow of trade. And you know, the government generally wants to see that there are kind of like, you know, like multiple, like that you have a lot of clients. So 3 or 4 clients just maybe too low. And then another reason for denial may be that, you know, there is just like not enough transactions happening. So like, let's say that you do have, you know, you have like 15 clients you are trading with, but with each of them, you only kind of like, you know, if you are, let's say you are importing something, you only issue them like 1 to 2 or 3 invoices to each of those 15 clients. Again, you know, like that just may be too low, because the government generally wants to see that, you know, there are just like a lot of transactions with each of those clients, you know, in the last couple of years. Then, you know, another reason for denial may be that you just don't meet the kind of like the 50%, you know, trade requirement. So like, let's say that, you know, you were, you know, like you have been trading with the US for last couple of years, but, you know, the trade, you know, has been, you know, like always below 50%, you know, then you just kind of like don't meet like one of the requirements. So that may be a reason for denial. And then, as I mentioned, you know, like if you are applying for an E-1 visa, but the trade is not existing at the time you are applying, then they will not issue the E-1 visa. So, like even if you submit a business plan with the application and you explain, like, oh, this is the trade that's going to happen, as I said, for the E-1, there already has to be a trade happening, for the government to be able to issue the E-1 visa. If the plan is that you just kind of like want to set up a company in the US and start a trade with your home country, and you kind of like need to come to the US and like meet with, I don't know, like suppliers there, or like, like set up the company and stuff like that, then a B1 visa, business visitor visa, may be, a best visa to apply for. So you would basically apply for that, do kind of the initial activities, and then, like you would have to leave the US. And then once the trade starts, then you could apply for an E-1 visa. And then, how can you renew your E-1 visa? And, like, is there a kind of like a limit of, like how many times you can renew your E-1 visa? So, in theory, you could renew your E-1 visa indefinitely. Like there is no limit, like amount of time, like how many times you can renew it. One thing to keep in mind is that, that E-1 visa is still a non-immigrant visa. So like if you, like let's say that, like your E-1 visa for your country can be issued to, for 5 years. And, like you are renewing it for the 5th time, meaning that you have been living in the US for 25 years. I will say like at some point the government may kind of like want to see like more evidence and may start to kind of like question the non-immigrant intent. Like if you have been kind of like living in the US for such a long period of time. But, like generally, like we have many clients who renew it like multiple times, 2, 3, 4 times. And it's, like it's fine. And as I said, like you could theoretically renew it indefinitely. But as I said, at some point, they may want to see more evidence or kind of like question it more. So what do you submit in the renewal application? So, it's basically the renewal application. You have to meet the same requirements, as for the initial application. So you have to, you still have to show that there is an ongoing trade. The trade is substantial. The trade is principally with the US. So it's going to be basically like the same, you still have to meet the same requirements. The kind of evidence you need to submit, it's going to be the company's tax returns, like showing the company's revenues, the trade spreadsheets, like outlining the trade. And then again, like a sample of invoices, sample of bank statements, like showing incoming payments from clients and stuff like that. And, as I kind of said in the beginning, it's always, very important to kind of like check the website of the consulate where you are applying, just to kind of see what are the exact documents that particular consulate wants to see. Because, like different consulates want to see different things. Perfect. So now let's go over some questions we got. Okay, so let's see. So the first question is, does it have to be export to US from my country, or does importing from the US into my country also qualify? Yes, so either of these qualifies. So like, like it can be either one. So like, let's say that you have a company in your home country and that company is exporting like something to US clients, that would qualify. But it's also fine if you set up a company, in the US, and that company is kind of like exporting to, like companies or like individuals in your home country. So either of these would be fine. Another question is, I'm on E-1 visa for the last 7 years. Currently, I import clothes from Pakistan to the US. My question is, can I open a new company in the US which can import services, web development, IT services, digital marketing from Pakistan, which is treaty country? So this is a good question. Basically, I will just kind of talk about this a little bit more generally. So, the E-1 visa is always issued for a specific company. So even, like on the E-1 stamp, you have a name of the company, that's the E-1 company, and that's kind of like the company the government approved. So, like if you want to set up like a different company and then you would need to go back to the consulate and kind of like get an approval for the E-1 for that company as well. If you want to kind of like do the trade under the same company, again, you would need to go back to the consulate and, like let them know, like submit a new application for these new services, because it seems it's very, selling a clothes and then these services you outline are just kind of like very differ from each other like substantially. Sometimes, like when the E-1 company wants to start, like wants to offer like or wants to do like additional things, but we can kind of like say that they are just kind of like outgrowth of the original trade. In those cases, you wouldn't necessarily have to go back and get an approval from the consulate. But in this case, it seems, like importing clothes and then doing like web development, IT, it just seems, like very, like different from each other. So you would basically have to go back to the consulate and get an approval for these additional services, because, the E-1 they approved was for the import of clothes. So they would want to see kind of like, you would just kind of like have to go back to the consulate and get, additional approval. Another question is, my wife already has social security number. Can she operate a business separately, which will have no connection with my business? So, so as I said, E-1 spouses can work in the US. The only kind of thing to check is, on your wife's I-94, the category she was admitted under has to be E2S, as E2 spouse. If she has, this I-94, she can basically, and she has social security number, then she can work for any employer. She can start her own business. So she can, like work in the US, do whatever type of work she wants. So this is that. And last question is, in this case, the sale takes place in my home country and my presence in the US is needed to make contacts and purchases. Yes, I would say like, for this, we would just kind of need additional, like information. If the trade is only happening in your home country, like you have a company in your home country and that company is trading with clients in the home country, then there wouldn't be any, international trade. So for the E-1 visa, there has to be a trade between the US and your home country. So there would either have to be an entity in the US that is trading with clients in your home country, or an entity in your home country and trading with US clients. So, either way, there has to be kind of international trade happening for the E-1 visa. But yeah, we would probably need kind of more information to, to advise on your case. Okay, so these are all the questions we got. Thank you so much, everyone, for joining us today. And as I said, we'll be sending all the materials as I mentioned in the beginning. Okay, thank you. Bye.